And we're good.
All right, very good. So it is a little after 5 on October 7th. I would call to order the meeting of the City of Green Bay Ethics Board. I believe that there is roll call taken electronically here, so we'll move to, and it does appear that we have a quorum so that we can proceed. So we'll move to item C, that's approval of the agenda. Is there a motion to approve the agenda for Wednesday, October 7th, 2020 Ethics Board meeting?
Motion to approve. Second.
We have a motion and a second. Any additions or corrections to the agenda? Hearing none, agenda signify by saying aye.
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 Any opposed? Motion carries. Moving on to item D, approval of the minutes. We have in our packet a set of minutes from the September 1st, 2020 Ethics Board meeting. Are there any additions or corrections? Hearing none, is there a motion to approve?
Motion to approve.
I have a motion. Is there a second?
I'll second.
I have a motion and a second. Again, last call, any additions or corrections? Hearing none, all in favor of approval of the minutes from the September 1st, 2020 Ethics Board meeting signify by saying aye. Aye. Any opposed?
So you called in, and what was the problem?
All right, doesn't sound like there are any opposed, so that motion carries. Minutes from the September 1st meeting are approved. Moving on to regular business, do we know if we have Alder Vanderleest connected yet?
Looks like Rob's still working on that.
May I interject? He told me that he can watch things or whatever, but he can't hear. You want me to have him try calling in again? What's the pleasure of the participants?
We can certainly have an opportunity to try calling in again.
Okay, I'll call him and you can go forward. I'll have him calling again. Okay.
Rob, you might want to have him check the thing at the bottom left where it goes through all the.
The start.
That thing. Maybe he's not catching
Okay,
that.
I'll give it a try.
Lindsay, I have somebody in the waiting room.
Yep, I'm on it.
Okie doke.
Thank you.
Yeah, John, why don't you call in again and make sure you push the start audio and start video, or something like that. Yeah. And does it work? Yeah, okay. Mr. Colney, he's got those buttons pushed. Has he been muted? Is that possible?
He's not muted. He just
Is it
shows
now?
up as not having audio.
Mr. Vandercastle?
Yes.
One thing that you have to do, it's almost before you get to that part with the microphone and the video, is when it goes in, it says connect with computer audio. You have to press that, and then you get to this screen. So he may have forgotten to press that part. That's before.
Did you hear Alderperson Dorff?
I could
Excuse
say it
me,
again.
Alderperson, might I interject and ask Alderperson Dorff to repeat that, and I'll put my phone near the computer. Okay, if that's okay.
Is that okay?
Sure. Yes, go ahead.
Okay, so John, you almost have to go back out, and then when you first get admitted in, it will give you a choice of connect with computer audio or connect with iPhone audio. You have to press connect with computer audio. And then again, when you get into it, you have to connect to the audio and the video. So you have to actually start out all over again. That could be it.
He indicated he will try it again. Thank you, Alderperson Dorf.
Trying.
All right, elected. Alder Vanderleest, can you hear us?
It looks like we still don't have audio for him.
How about connection by phone? Is there a way to do that?
Mhm.
Yeah,
I
we should
don't-
probably just have them dial in on the audio. Just have him call that phone number and enter the meeting ID, and he should be able to participate fully without video.
Why don't you just dial in on a phone and listen? How about that? It's 312 6226 just a minute, 312 626 312 626 6799. Or just a minute. Here, just try this. 312 626 6799. 626 6799. I think you need them. You know, if you get to that point, I'll give you the meeting ID and password. 2 626 6799. Okay.
This is Alter Vanderleest calling in.
We're good. We can hear you.
Okay. I'll get my my tablet going. At least I'll be able to hear what's going on in the meeting. Thank you.
Very good. Very good. All right, so getting back on our agenda, the procedural aspects of the meeting, we're now ready to move on to regular business. Item number one, we are scheduled tonight for a hearing on a number of motions that have been filed in this matter, that is the ethics complaint against Alder John Vanderleest as filed by Mr. Carl Knight under the City of Green Bay Code of Conduct for Elected Officials. You should have received packets of documents from, I believe they would have come through the packet with the agenda for tonight's meeting. There are a number of motions that were filed by the parties, some that were filed before our last meeting when a scheduling order was put in place, and a number of them that were filed after that scheduling order was put in place. The first one, Mr. Kelly, correct me if I'm in error here, but the first one, first motion filed was that by Attorney Miller for specificity. That one looks like it was filed back in sometime in late August, if I'm not mistaken. And it
Yes,
appears,
August 31st.
and it appears that there was a response filed by that. So is there, I would turn this over to Mr. Miller and Mr. Knight. Is there anything further that we need to address with respect to that motion?
This is Rob Miller. May I speak for a minute?
Yes, please.
My understanding at this point is that we're proceeding with the facts as alleged as a violation of the public meeting section of the Code of Ethics. And if that's the understanding, no further clarification is necessary.
Very good. Mr. Knight, anything to add to that?
No, I don't have anything extra to add other than.
All right. Very good. And just from my reading of it, I would assume it was my impression that that was the case, but the motion was filed, so it needed to be addressed. So then, looks like the next motion that was filed under the scheduling orders were a motion to dismiss that was filed by Mr. Miller and I'm sorry, and at the same time there was a motion to suppress filed by Mr. Knight. So both of those, it looks like they came in on September 18th. So, Mr. Kelly, do you have an idea of which one came in first? We'll go kind of in order which ones they came in.
They came in pretty much at the same time. The motion to suppress was based on on some evidence, an affidavit that was filed by Mr. Miller. And the motion to dismiss was an overall motion to dismiss the complaint.
And so then first one would be Mr. Knight's motion to suppress.
Yeah, it probably makes some sense to address that first.
All right, so Mr. Knight.
That's fine with me, by the way. I'm agreeable to that.
Okay.
I'm sorry, Mr. Miller, you're agreeable to what?
To his proceeding first with his motion.
Oh, okay, very good. So Mr. Knight, we will address your motion to suppress first. I know you have two of them. Looks like another one was filed in October, but we'll deal with the September 18th one first. So the floor is yours. You can address anything that you would like to the board regarding that motion.
Thank you. So filed by Attorney Miller was an affidavit, and that was signed or written or signed at least by Rhonda Sidnikow, who's a member of the Green Bay Area School Board, as is addressed in the affidavit. I had a conversation with Ms. Sidnikow about these hearings and about the issue here, and she was clearly unfamiliar with the case, with the whole situation. She had talked about a number of personal instances which are addressed in the affidavit, that she had been harassed on social media. But when I had explained to her the situation here with the formal complaint, in that a number of people in the community had been blocked and their comments and posts have been deleted, she didn't understand the significance or the pertinence to the relevance to the case. And she was concerned further that that she wasn't sure how this affected the case, because had she known what the entire situation was about, would not have come out to sign this affidavit. She has suggested that she's willing to come on and to clarify her stance on the things that are being addressed in the formal complaint, and that she's very pro freedom of speech. She, as a member of the school board, has many times allowed people to speak, even when their voices were disagreeable to her own opinions. And she has communicated to me that she's willing to come here to communicate about the policy of the school board in order to help to educate this board and any aldermen on the city council as to what she believes with the school board and other parties would be ethical, and how she would see that people could be heard, especially on social media. So I guess my motion to suppress here is that I'm not familiar, although I'm sensitive to her situation. I'm not familiar with how it's relevant to this situation, and furthermore, having communicated with her personally, it's clear that she's unfamiliar with it, and I think was a little bit upset that she didn't understand how she was being, in what context this was being used, and whether she was maybe being framed to be supportive of the respondent, when in fact her beliefs might align more with the complaint.
So basically, it sounds like that's, you're saying you don't know why it's relevant. You're objecting to the relevance of it?
Sorry if I should have been just more clear and succinct and simple than that. Yeah, I don't understand how this is clear, and I think that the person who signed the affidavit is unsure how it's relevant as well. It's a little confusing to me as to what this has to do with anything.
Thank you. Anything further, Mr. Knight, on this issue?
No, not on this issue.
Mr. Miller?
Alder Galvin has lost his connection, to tell you that.
Yeah, I noticed he wasn't there.
Yeah, he's trying to get back in. He just texted me.
So let's hold until Alder Galvin gets back connected so that we have a quorum.
Quorum, yeah.
Hi, this is Jonathan calling on.
He's trying to text me something. I'll let you know when it comes through.
Well, thank you for your assistance here.
Trying to help. Come on now. He's getting a message that his internet is down. Can I send him the phone instructions? Yes, I will. But I will mute myself so I don't sound silly.
All right.
Okay, he said his, oh, that's an interesting sound, isn't it? He said his internet said it's coming back up again. I said, stay on the phone with me, and then that sound came up, so he didn't. So we'll see. Here he is, and there he is.
All right, he's back.
You're muted, Alder Calvin.
It's probably a good thing I was muted. I said some things I shouldn't have about my internet and my phone connection. You know, I think I live just about underneath the tower and it never works very well. So thank you.
All right, very good. So just for the record, we took a brief pause here as one of our members, Alder Galvin, lost his internet connection to our Zoom meeting here. So he is back online and attending the meeting. So we will continue. Alder Galvin, is there anything that you missed from Mr. Knight in his presentation on his motion to suppress?
I hate to say this, yes. I think I checked out about the time he was saying he had talked to Ms. Sintekow and that she had related that she had a couple instances happen to her over the internet, I think on social media, but then that's when I got locked out.
Okay. Would you like Mr. Knight to readdress those issues for you?
If he could just briefly, I mean, I don't want to make everyone go through that whole thing again.
That's fine.
Or however long it was, but I would appreciate that.
I'll try to make it brief.
Thank you.
Yeah, actually, I've spoken with Ms. Sitnikow and I'm familiar with the situation, but I'm just unsure of the relevance of this affidavit to this case. It's and furthermore, it seemed like I don't know if bad faith is the correct term or not, but Ms. Sitnikow wasn't familiar with this entire formal complaint, the situation, the basis of it, and had she known, she communicated to me that she probably would not have had not cooperated with submitting something, and furthermore, she is staunchly pro allowing the community to speak and not deleting their comments, and as a member of the school board is entrusted with a number of different stipulations that disallow her and other members of that body to do so. So she would come out in support of this complaint, and if it's applicable, I would love to call her in when the time is right to do that. But that's the basis of my motion to suppress. It's not relevant, and I think it might have been in bad faith, and that's it.
Okay, thank you.
So next, we were about to give Attorney Miller a chance to respond. So Attorney Miller, the floor is yours.
Thank you. Well, with regard to the affidavit, I spoke with Ms. Sitnikow at some length, explained exactly what the situation was, just for informational purposes. Thereafter, I called her again and asked her if she would be willing to sign an affidavit outlining her experiences with death threats via voicemail and social media, with which she has received, and in fact she has a injunction against an individual who's made these death threats. The exact relevance is that I've cited Section 230 of the Communications Decency Act, and I am a big proponent of First Amendment rights, the ability to speak. But I think when people are making death threats to anyone, and most especially a public official, that needs to be policed and addressed. And the ability to do so is contained in that Section 230 of the Communications Decency Act. And my view is that the ability to police and delete posts is absolutely inherent in reasonable and decent discussions. And I would further add that my material from the Wisconsin Ethics Board, the people that supervise ethics for the state legislators and advise local attorneys on this, indicates that state legislators have the ability to police and manage Facebook posts. So it's entirely consistent with my defense that public officials need the ability to police and manage their posts so they don't have, so they're not put in a position of endorsing repugnant postings on their social media items on the internet. So it's relevant. It's Ms. Sitnikau was well aware of what's going on. I talked to her multiple times. I had to solicit the affidavit. I don't know where Mr. Knight is coming from with that recitation, but it stands as it is, and I guess it's a matter of debate if we get to that point.
Mr. Miller, a question. I'm not sure I heard you correctly. Did you say with this particular person that there is a restraining order or an injunction or something?
Yes, against the person that made the death threats on social media and voicemail. So she has every reason to be supportive of the ability to police and manage Facebook posts, and that's where this is coming from. And I've outlined the Section 230 of the Communications Decency Act, which permits people. I've cited that as preempting local laws to the contrary.
All right. All right. Any board members have any questions for either party? Yes, sure.
So, all of the information that I've read so far, were there death threats involved with the social media talking about with this here?
May I address that?
Yeah. Whoever.
No death threats. My understanding is that there were names, inappropriate names utilized, and also there was some disparaging of Mr. Vanderleest's business and his integrity. Those are the types of things that were present here, as well as just things that were off topic.
Tonight?
If I may address that, none of the material which I have come across have been supplied with, which makes up the basis of shows that there's any evidence or proof of anyone threatening anything or making any sort of bad faith or rude or inappropriate remarks. Everything has been very succinct with the business of the office of Alderman and city issue and address those, and those are all included as exhibits. And also, Ms. Sitnikau has also not deleted any of the posts which were made, and she has allowed all of the posts and comments on her professional school board posted, even though there is an injunction. She's even allowed those to remain. That's how staunchly she supports freedom of speech. So I'm not sure I'm not sure what's going on.
Okay. Any further questions from the board?
I have a question.
Go ahead.
I guess I'm wondering if Attorney Miller is saying that based on what's happened to Ms. Sitnikau, you think that justifies Vanderleest deleting comments that he doesn't agree with on his Facebook page?
That's the argument.
And so because what she does, you think if it's good for her to do it, or it's because she got threatened?
No, that's just an example. The basis of deleting posts is Section 230 of the Communication Decency Act and the Wisconsin Ethics Board with regard to policing and managing Facebook.
Okay, so it's just an example of what happened.
That's just an example, yes.
Okay.
I'm not suggesting that the fact that it occurs makes it important. That's simply the basis for its relevance.
Okay.
And we've got a lot of real world examples that are occurring daily on Twitter and Facebook and the like of death threats. So that was the one that I had access to. I had access to a specific individual, but that's common knowledge to anybody that's reading the news.
Okay, and I guess the follow-up comment I have to that, and Mr. Kelly, if I'm out of line, shut me down right away, but I seem to recall in the recent past, politicians, state level in Wisconsin, who were reprimanded or there had some kind of hearings because they were deleting Facebook posts and comments from followers, and they were reprimanded or they got in some kind of trouble for doing that. So I'm just wondering, how this, you draw this conclusion, but I've paper and seen on media where it's the opposite of what you're claiming here.
And may I respond to that?
Yes.
There are cases all over the place. There's a case that I cite in my brief. The governor of Kentucky did basically exactly what Mr. Vanderleest is alleged to have done, and he was upheld. His actions were upheld by the district court in Kentucky. So my point is not that, or my point is that it's an area of flux according to some judges. There are diametrically opposing decisions in this area, and in that circumstance, it's not clear which path to follow. And I'm suggesting to you that there are divergent paths, and it's unclear what is appropriate at this point. Is that responsive?
Yeah, that makes sense. All right, thank you.
Any further questions from any of the board members regarding the motion to suppress? All right, hearing none, I think the next motion up then is Attorney Miller's motion to dismiss. So Attorney Miller, I will give you the floor to address your motion.
Okay, I'm going to just hit the highlights because I did file a 5-page brief that went into these points in substantial detail. So I'm going to start off at the most remote level and then home in on the specifics as to why this should be dismissed. First of all, I want to go over a couple of general considerations here that I think have to be kept in mind, and they're pretty simple ones. When we seek to punish somebody, either via criminal actions or ethics boards actions or somewhere in between, we state the conduct expected in clear, unmistakable terms. When we write a statute or ordinance, it should be very clear. The courts apply the rule of stare decisis, so we apply previous precedents so we have people know what to expect. In this case, if we're going to the aspect of public meetings, this is a complete surprise to anybody as to the meaning of public meetings, and also just from the standpoint of the relevant cases which I addressed with the exchange with Mr. Alderman Galvin. And also there's a certain idea of this. Sometimes we talk about it in stark terms of the ex post facto laws. We don't charge you with driving through an intersection improperly and put up the stop sign the next day. So here we have at the outset of this, we have cases from the Second and Fourth Circuit Courts of Appeals that really have no application to this jurisdiction. And that's one of the themes that runs through this proceeding. We also have conduct that really appropriately wasn't within the scope of, I believe, the ordinance, the public meeting section. And finally, we have the complainant citing social media sections of the personnel policy that simply wouldn't be applicable to city council members. So that's where we start. At this point, we have boiled it down to the public meeting section. We are looking at Mr. Vanderleest's conduct as a violative of a public meeting. And I go over that aspect in some detail. We have definitions of a public meeting in Wisconsin, and I'm citing section 1982 sub 2 of the Wisconsin statutes. It's basically the convening of members of a body to conduct business. And I further cite a case that states that we don't have one-person public meetings in Wisconsin. It's very plain and in fact, that's the canon of construction that I'm citing here or utilizing. We look at the plain meaning of the term when we're trying to interpret an ordinance or a statute. The plain meaning of public meeting would not include exchanges on a Facebook site or a Twitter feed. And in fact, if we expand or push or contort the meaning of public meeting to something else, what wouldn't it include? I indicate, would it expand to meaning to a chance meeting on the street or in a store or in a place of worship? What wouldn't be subject to this ethics code if the public meeting limitations are eliminated? And I also note that we don't look for ambiguity in trying to understand what an ordinance means. I believe that public meeting is perfectly clear. I've given you some definitions, and I cite a couple of cases indicating, and some authorities, to the extent that we're interpreting an ordinance is not a search for ambiguity. And I think a reasonable English speaker would understand what a public meeting is very easily. And if there are any doubts, one goes to the Wisconsin statutes or even the city's codes of ordinances. A public meeting in Wisconsin by the city of Green Bay is always noticed for the press. We have no notice for open meetings law purposes for any exchanges on Facebook. And in fact, I just suggest that if we start transmuting public meetings to be Facebook exchanges, the city of Green Bay is going to be violating the open meetings law multiple times a day. The other canon that I look at in trying to interpret what a public meeting is the rule of lenity, or leniency. Basically, the idea is that the defendant is given the benefit of the doubt, very simply. If we're seeking to punish, the defendant is being given the benefit of the doubt. We utilize that in the beyond a reasonable doubt standard in our criminal cases. And when we utilize that to look at this ordinance, we would keep it at its current meaning or contract it. We don't expand it to encapsulate new vistas of public meetings that were not contemplated by the city council. And I use a quote by the United States Supreme Court, and I'll repeat that here, and I quote, the conduct proscribed must be defined specifically so that the person or persons affected remain secure and unrestrained in the rights to engage in activities not encompassed by the legislation. Blurred signposts to criminality will not suffice to create it. Now, obviously, there's no criminality here, but the same theories apply. And it's very strange to me that my client would be thought to have read the advance sheets of the Second Circuit Court of Appeals or the Fourth Circuit Court of Appeals, or even now would be contemplating that a Facebook exchange or interchanges in the course of a campaign is a public meeting for the purposes of the ethics code. And I might note here, and one of the basis of the motions to dismiss is that it creates two sets of individuals. The individuals that are running for public office, the incumbent, are under the strictures of this code of ethics as it stands or as it's interpreted, whereas the challengers can do whatever they want, which seems to be profoundly unfair. I guess one of the very important aspects of this interpretation in my brief is that the ethics board is not empowered to legislate by rewriting city ordinances. The city's personnel policy is not relevant to the alderman, and the legislative power of the city of Green Bay was not vested in its ethics board. The city council did not delegate to the ethics board the right to legislate. It passed a specific set of ordinances with regard to what is contained or what is subject to the ethics board. It did not specifically incorporate social media. It could have. It obviously spoke with regard to the actions of its other employees, but it chose not to. So for the ethics board to expand this ordinance beyond the normal definition of public meeting is essentially to rewrite a city ordinance. I also addressed the sections 230 of the Communications Decency Act, which preempts any state from enforcing, or state or local government from enforcing anything that's contrary to its dictates. And one of the things that is granted under the Communications Decency Act is the ability to manage and delete objectionable posts. I guess the other point here is that there's really no violation of any controlling law whatsoever, and this is probably surprising, but the jurisdictions of the Second Circuit Court of Appeals and the Fourth Circuit Court of Appeals have no application here. We are sitting in the Seventh Circuit Court of Appeals, and they have not spoken on this. At least in the Eastern District. In the Western District, that's else, but there is no controlling precedent in the Eastern District of Wisconsin, and that's true of state law as well. So for someone to figure out what's appropriate or inappropriate would be very difficult. As I've told you before, there are conflicting opinions on this, and I cite Morgan versus Bevan from the Eastern District Court of Kentucky, which approved the basically the same conduct we're analyzing here. And I think importantly here, the court said that there's no constitutional right for a person to be heard. Nothing in the First Amendment indicates that a member of the public has a right for the representative of the government to listen to him. So this is exactly analogous to someone ripping up a letter or reading a letter or ripping up, failing to take a phone call, turning away from a discussion because they want it to end. This is exactly what's done every day by public officials. Granted, maybe you think that it would be better, maybe it would be better if every constituent was heard out to the end. But in our public meetings, we control access to the floor, we control time, we eliminate people's right to speak. Sometimes we deny their right to speak entirely. So what happens on Facebook or Twitter is exactly the way that we conduct public meetings. We control access, and there is no constitutional right to be heard. In fact, a legislative body can legislate without hearing from any member of the public at all. Now, I guess the overriding concern here is that the ethics standards need to be clear, they need to be clearly understandable, and they need to be made available to the people that are supposed to comply with this. I indicate that it should not be a scavenger hunt or a guess as to what the public officials should do with regard to the compliance with the ethics code. There's no way that, I mean, I don't know how many of you were familiar with the Second Circuit or Fourth Circuit Court of Appeals cases or the Western District cases, but I knew very little about this, and certainly I would not have been able to give an opinion on the applicability to the city of Green Bay's aldermen. And I think it's important here to measure the standard that Mr. Vanderleest is being held to. He is apparently being told that he must understand in advance what a public meeting is, and that it's been transmuted from a regular public meeting at City Hall or via Zoom to virtually anything, that he should review at his peril the decisions of the Second Circuit Court of Appeals and the Fourth Circuit Court of Appeals, even though they have no applicability here. And what of the city attorney's office here? It's interesting that they never warned Mr. Vanderleest about or any alderman about the conduct of websites. In this case, the website was a campaign website. And I would submit to you that the reason that the city attorney's office failed to warn is that, much as I said before, we have conflicting cases. It's in a state of flux, and it's really unknown. There is no controlling precedent. So Mr. Vanderleest is being held to a much higher standard than anyone else, even as it, on one line of cases, is perfectly acceptable. So let me just summarize the motion to dismiss. I think I've argued about or mentioned most of them. I mean, the advice of the Wisconsin Ethics Board, which I've submitted in a previous filing, seems to be perfectly consistent with his conduct, that state legislators have the right to manage posts. That was the last posting that I could find on the Ethics Board website, which I produced in full. I guess the other aspect of this is the idea that one has to speak with clarity. If you want people to comply with ethics standards, it has to be clear in advance, not changing the definition of public meetings after the conduct has occurred. And that's what I would submit is occurring here. It's not an ex post facto law in the general meaning of that. It's changing the definition of the term after the conduct has occurred. So for all the reasons I've cited in my brief and my motions, I think this action should be dismissed. If we are interested in solving the problem, it seems to me the problem should be solved by a communication to the city council to specifically outline what members of the city council should do or should not do in social media. To the best of my knowledge, that has not been done. There has been a submission by Person Dorf to ask to have the city attorney's office offer some training. I think that's a very positive step, but putting heads on posts such as this proceeding to punish Mr. Vanderleest, the problem needs to be solved by clear, unequivocal standards of conduct posted in advance of the conduct taking place. And at that point, these problems will not arise. And I'm in favor of solving the problem as opposed to punishment for the sake of punishment. Thank you, and I would appreciate if this matter was dismissed.
Okay, thank you, Mr. Miller. Mr. Knight, any response to Mr. Miller's argument?
Yeah, I think so.
Mr. Knight, just hold on. Could you turn up your volume somehow? I'm having a hard time hearing you.
So what I'll do is I'll come close to the computer and I'll speak a little bit louder so you can hear me.
However you want to do, it's fine. Go ahead.
If I may, Mr. Chairman, if I may, Lindsay, if you could allow me to share, I'd like to make sure we clarify some of the arguments, because there's some things in the motion that I don't think were discussed that I think are important for the board and when they deliberate. And I want to make sure the board understands kind of the basis of Mr. Miller's argument. So
you're still a co-host, so you should still be able to share your screen.
Okay, it wasn't allowing me to before. Okay, code of conduct.
Are these what you're pulling up? Okay, very good. That's in our packet as well, I think, but go ahead.
Okay, can you folks, where am I on the, for some reason I'm blind to it.
You've got section 4 of the code of conduct pulled up.
Perfect. And I want to make this clear to everybody because this is exactly what Mr. Miller was arguing about. And I want to make sure that Tarl responds to this because I do think this is an important issue. The provision of the code that Mr. Knight quoted is this provision. He quoted it starting, "No signs of partiality, prejudice, or disrespect should be evident on the part of an individual council member toward an individual participating in a public forum. Efforts should be made." And then he went through the rest of the statute. The rule. What Mr. Miller is pointing out in his argument, and in the position he appears to be taking, is that this should only apply in public meetings. Mr. Miller, am I correct in that interpretation and trying to clarify this for the board?
That's, I understand to be the plain meaning of that ordinance.
Okay, very good. Now, I'll probably have some questions about this after Mr. Knight has a chance to address it. But I just wanted to make that clear to the board that that's where he's coming from. That's where Mr. Miller was coming from. I also would like to talk about a couple other issues that I think are important that are in Mr. Miller's motion that were not discussed at this point in time. Let's see here. Let me find the right motion. I've got to go to the share. Okay, and let me share something else here, if I can find it in time here. Okay, got to find your motion here, Rob. I'm not sure where I have it. Is that which motion do I have up there? That's the motion.
Motion to suppress.
No, that's not the one I want to share.
These
What I'm
are
trying to find is Mr. Miller's motion that actually sets up. I can find it on my screen, but I can't seem to find it here.
can address those as Mr. Knight goes through his presentation.
Yeah, I was kind of hoping we could look at those so that Mr. Knight could respond to each.
Right.
I can find it if you would like.
Why don't you do that for me and then put it up? In the meantime, Tarl can start addressing this first issue.
Is it the brief supporting the motion to dismiss?
No, what I think is important is the motion to dismiss. It's shorter, easier for the board to understand. And I think we can walk through that a little quicker.
Okay.
It's just a 1.5-page document.
Right. Right. It's a shorter document, easier to go through.
It's got 8 stipulations on it.
Hey, Mr. Knight, make sure you.
All right. Now, is now a good time for me to continue on?
Oh, well, one thing I just wanted to clarify with Mr. Miller. I noticed that Mr. Miller also believes that the charge regarding social media section should be dismissed. You didn't touch on that very much, Mr. Miller. Can you clarify that portion of your motion before?
Well, my understanding is that the social media section he refers to, and correct me if I'm wrong, is the personnel policy of the city, and it would not be applicable to a city council member. Is that the case?
That's one of the things we would be deliberating on and discussing.
Okay. Is my understanding correct that that is a personnel? When I saw it on the internet, it said personnel policy or something like that.
I believe it is one of the personnel policies. In fact, I'm quite sure it is.
And my understanding, and if I'm not supposed to ask the question, Mr. Conley, you tell me, but my understanding is that city council members would not be subject to the personnel policy of the city of Green Bay. Is that correct, or?
Well, that's going to be your position and we will discuss it.
Okay.
I understand what you're saying. That they're not employees, that they're not subject to
Right.
it.
Yeah.
Okay. The second thing, the public meeting argument we've already covered. It's 230 decency. What's the next issue? If you could, number 4. I think you did cover the rest of them. Those were the 2 that I wanted to make sure were covered, I believe. Okay, but those are the issues. That pretty much sets out, this document pretty much sets out the motion that Mr. Miller has made, that Mr. Knight, you probably want to respond to those issues for the board.
Yeah, please.
Can I ask a question for clarification at
Mhm.
this point, or
Yes.
do I need to wait?
No, go ahead.
So I guess I'd like to know if the social media site we're talking about was a campaign site or not a campaign site.
May I
Because I think, Mr. Attorney Miller, you had mentioned it was a campaign site. And I think some of the things I saw looked like an aldermanic site, not like a campaign-related site. I'd like clarification on what the site was, the social media.
It
Facebook page.
started, if I may, this is Rob Miller. It started as a campaign site. It was put forward as a campaign site in his first campaign, which he lost, and he just continued that. And most of the postings, at least my understanding, is that many of the postings that are in dispute here were occurring in the course of the campaign for his most election. So he considered it a campaign site. And I've supplied documents indicating that he put that he was a politician, and there's obviously a mixture of materials for a sitting alderman to tell people what he's accomplished and why he should be reelected. So
He doesn't have 2 sites then, in
distinct-
other words. He doesn't have 2 sites then.
No, he doesn't.
Just has 1 site. Okay.
No, he doesn't have 2 sites, and I might further clarify, it's not owned and operated by the city of Green Bay, which distinguishes itself from the Fourth Circuit Court of Appeals case. So
Thank you.
His position is it's a campaign website, and we'll leave it at that. Thank you.
All right.
I had one question. This is Aaron. Can everybody hear me?
Yes.
Okay.
Yes.
In the section on public meetings, it uses the word forum. Is the interpretation that forum is just a synonym for meeting? And then also it describes how people should conduct themselves publicly and privately. But if a meeting is public, then there's sort of a disconnect there, right? So is that section saying that in private communications during public meetings, like if I lean over to another alderman and say something, I have to be respectful and honest and have integrity? Or is that sentence talking about my conduct outside of the council chambers? I guess I could read that paragraph in a couple different ways. Forum doesn't necessarily mean meeting. Conduct conducted privately could be conduct conducted when I'm not officially sitting in a city council meeting.
Do you want me to respond?
I mean, you'd spent a lot of time talking about the definition of meeting.
Right.
And so I'm wondering if your interpretation of is that it's a meeting?
Yeah, the heading says public meetings. It's describing a public meeting. In addition, further down in the Code of Ethics, it's going through conduct outside of public meetings. So I am interpreting that my interpretation, I think it's a reasonable one, is that public meetings, when it says a heading of public meetings, it's referring to public meetings. We have specific definitions in the Wisconsin statutes and the Green Bay City Code of Ordinances. I think it means what it says, and public forum is just a variation on the on the term public meeting. So given that we have a demarcation between public meetings, that heading, and the next one outside of public meetings, I think it's a distinction, and I think that it makes some sense. I think one can reasonably expect a public official to have a welcoming and decent demeanor when people are speaking to you as a incumbent city council member in a public meeting. That might not be the case if you're engaged in a private internet exchange during a campaign. I see a substantial distinction between the demeanor that one can reasonably expect at a public meeting when people are offering their viewpoints and you're an incumbent official versus outside of that setting.
What do you think what's your interpretation of what the private conduct, public and private conduct? I mean, if public meetings are public, then what's the private part about?
I think the private conduct, I don't have that section in front of me, so I'm going to have to wing this, but I think it's I
think we can put it up so you can look at it real quick.
Okay, that would be great. My recollection here is that it's referring to city council members representing that they speak for the city council when they really can't speak for the city council, or making misrepresentations to members of the public as to what they can do or what the viewpoints of the city council is.
Is that up now?
I think we have to go down further.
You see, okay.
It says city council members are expected to demonstrate both publicly and privately their honesty and integrity and to be an example of appropriate and ethical conduct. How does privately apply? My thought is that is intended to be a more general statement. It can't be private conduct if it's in a public meeting. Otherwise, it makes no sense.
No, certainly it can. Certainly it can be private conduct. I mean, as between other people or between other people in the room.
Okay.
Any further?
At least, I don't think I understand your point. I mean, your viewpoint is a reasonable one. I don't think there's only one reading there, and I think when it's talking about, I think there's more than one reading. That's the reading that I see there. If you, Mr. Conley, if you can scroll down further, you'll see.
I'll try here to see if I can make it work. Is it scrolling?
Yeah.
Yes.
Yeah.
Oh, okay. Okay, then I am seeing what you're saying.
It says outside public meetings.
Yeah, if you go down further, conduct with other board members, elected official, enforcement. No, I must have zipped by it. Okay, outside public meetings. Is that what you're talking about?
Yes. Make no promise on behalf of the city council, or that's an addition. So it's making a clear distinction as to what's happening. But from my standpoint, I've been a public official, and I've had paper airplanes thrown at me at a public meeting. I would say that conduct, and presumably it wasn't seen by everybody. I don't know. I mean, you could definitely have outrageous conduct that may well be only known to some of the individuals that are members of the body. So I don't see that it's that my interpretation is ruled out. In any event, I think there's multiple interpretations of what public meeting is suggests that if you want to sanction somebody, it should be clearly defined what the ambit of public meeting is. And I would submit that regardless of what reading one has, that a Facebook exchange doesn't fit within that.
Okay. Thanks for the clarity. Just wanted to follow up on those things.
So, Mr. Knight, you've heard some vigorous discussion here of various points that were raised by Attorney Miller in his brief. I'd like you to respond to those and make your, or provide us with your position on that motion to dismiss and the points that were made. So hopefully there's some clarification here from this recent discussion as to what those points are. And I will turn the floor over to you. Just again, remember to speak loudly so we can all hear you. Go ahead.
Thank you, Mr. Vanderkessel. Before I go on, I want to make sure that Alderman Galvin is still in the
No.
chat.
Mr. Knight, we're having a hard time hearing you again.
Before I continue, I just want to be sure that Alderman Galvin is in the chat because
There he is again.
okay. Well, you know, I don't want to have to go through the whole thing again.
I'm sorry, my wife was up talking to me, so I had the picture blotted out. She'd kill me if I put her on this form, so.
All right, well, I want to begin by talking about Section 4 of the Code of Conduct that we just went over. And as it was brought up by Lenshay, you know, there's the terminology public forum used there, not just public meeting, and in a number of different places in the formal complaint, and as has been brought up by Mr. Miller, I have cited a number of cases, which are federal cases, and although they don't reach as far as our federal district here, they do in both of those cases, Knight versus Amendment Institute versus Trump in 2019 and Davison versus Randall in 2019, both refer to public official social media accounts as public forums. And although Mr. Miller has gone on to discount those cases because they don't extend to this district, he still continues to cite the governor case, which supports his cause. So I think that there's a double standard there, and I think there is a precedent set anyway at the federal level for what can happen at state and local levels for public forums constituting social media accounts. And what is social media? You know, particularly Facebook, which is the social media brand that we're talking about here, where these offenses were committed. They're places where people gather. They're not physical locations, but they are virtual locations where people can gather virtually. And there are forums there, online forums. And that's a term that's referred to when we're talking about things like Reddit and Tumblr and Facebook, the public forums. And this is where the public can gather and communicate and be open about debate and about policy and about their opinions. And in no place on any of these pages, particularly, although a number of offenses have occurred, resulting in people being blocked in private communication with that page, most of these offenses are happening publicly, where they're made public, they're happening in public. Anyone with or without an account can go onto the internet and can engage in these communications that are occurring with groups of people. None of these are singular. They're all groups of people communicating in a number of places on this social media account. Constituents and other people in the city are asked for their opinion. He's asking for their input. And so they're doing that. And they're not doing it in a private way, over private correspondence on email or in message or on the phone. They're doing it in a public place. So I think it constitutes a public forum. And I think that there are federal and state examples of that to back that up. So I don't subscribe to or agree with that this isn't a public meeting or a public forum, even if it's not called to action. Public input was asked for, and it was expressed in a public place where people can engage in a public conversation. And I think if we're going to discount that in the 21st century, then we've got to take a look at language and exactly what's going on here with falling behind in the 20th century. It's been 20 years now that social media has been being used, and all of these people cited in this complaint are hardworking, tax-paying people who have jobs and families, and this is their way of communicating with their aldermen in a public way. This is their way of doing it. Secondly, I wanted to talk about the page itself, because the matter is kind of being tossed around depending on the status of the page being a public official account or a campaign account. I've included in exhibit to everyone here all of the campaign posts and non-campaign posts which have been posted on this public page. There are 115 posts that were made as of the creation of this page as of April 10th, 2020, which is when this compilation of posts was made. Now there's no definition of what a campaign post is versus an official city matter post, but it was my delineation that the vast majority of these posts do not contain campaigning material, and a wide majority of them, 78% of them, were posted not during election cycles, in between the time when a campaign person or an elected official hopeful has to file for candidacy versus when the election occurs. So there's a small window there of a number of months, and 78% of these posts, 90 of 115, were posted not during that time frame. I don't think that those constitute as campaign posts because of that. And because that's almost 80% of the posts made on this page, I would argue this is not a page that is being used for campaign purposes. Not only that, but Facebook has a rigorous third-party confirmation process, which they can confirm the status of an office, so that not everyone can just create a Facebook page claiming that they're a public official. Facebook has the ability, and they do go ahead and confirm with local sources or state sources, or sometimes federal sources, whether those are election campaign submission documents, or whether they're a matter of public record, whether you are indeed running for office and for what district, and they confirm all of that before you can go public with this information. And they also confirm whether you've been elected or not. So they know what they're doing there, and they have on Alderman Vanderleest's page confirmed it to be a politician site. This is not a political campaign site. There are two different terminologies that they use to differentiate between the two. There's a political campaign, and there is a politician, which means that you're a confirmed politician, which means this is no longer a campaign site. This is now a public forum for you to be able to discuss city or state or federal issues that correspond with your office and the office that you've sworn into. And so almost 80% of these are not campaign related, and Facebook doesn't confirm that this is a campaign page at all. In fact, just the opposite. This is a confirmed political public official page. So anytime that has been brought up that, and actually just further one more point on this is you have to have you have to have a personal campaign, you have to have a personal Facebook page in order to run a public face, whether it's a campaign page or a political campaign page. And Alderman Vanderleest, to my knowledge, does not have one of those. He does not have a personal Facebook page. So I'm wondering if he doesn't, and if evidence can be supplied that that's true, then I'll believe that. But as far as I know, talking to a number of sources, he does not have his own personal Facebook page, which means he cannot own or operate this public page. So I'm wondering who is running the site, because it's not him. And if it's not him, then someone else is involved here who might also be at fault, or someone else is partially responsible. And Mr. Vanderleest is therefore responsible for allowing them to make these changes and delete people. And I brought that up in a number of different exhibits that I've submitted, but I don't think that this is just one person. So in any case, I want to continue on. In the Code of Conduct, in Section 4, as has been brought up now by Mr. Colney and Mr. Weinshank, I've sectioned off a number of different sentences that, whether you agree with the public forum or whether you don't agree with the public forum stance, and I hope you do, because I do believe this is a modern public forum, as has been declared by these federal cases, these federal judges. No signs of partiality, prejudice, or disrespect should be evident on the part of individual council members toward an individual participating in a public forum. And besides that, all council members should convey to the public their respect and appreciation for the public's participation, input, and opinions. Now, on this page, those things were asked for, all of the communication that has occurred. And if there's evidence of people being rude or inappropriate or slandering him or giving him death threats, I've not seen any of those. I've not seen a single bit of evidence supplied for that argument. I haven't. All of these things are honest people asking about Colburn Pool, asking about their street, asking about taxes and the wheel tax. These are people who want to know because they have busy lives, and this is their way of communicating. And I wonder if when their input and opinions are asked for and they supply them, when they're not agreed by the alderman, why are they then deleted? Does that match the Code of Conduct section, which states that that council members should convey their public their respect and appreciation for the participation, input, and opinions? I'm not sure why he's asking if they're just going to be deleted. It's confusing to me, and this isn't a silly quarrel or a vendetta or something. These are people who for a number of years have felt and have expressed many times on social media, in other public forums and in person, and have written to me and expressed to me when I visited their homes. And I had no knowledge of this. They didn't have to bring it up with me, but they were that concerned about, they felt that their participation, input, and opinions were not appreciated and were not respected. In fact, just the opposite. They were removed, and they were met with combative communication and rebuttal, and they have no chance then, in order to communicate that, because they're blocked from the page. They have no chance to continue that conversation. A number of these people also separately cannot communicate with the alderman by phone. And a number of people are concerned that they're not given any attention because they openly supported another candidate. So there are a number of issues here with that, whether you believe that the internet constitutes the public forum, if it's just kept in a general sense anyway. There is partiality, prejudice, and disrespect evident here on the behalf of this individual council member, and all of these people feel very strongly that they're not being appreciated, and just the opposite. So I wanted to bring that up again, because that's the basis of this. Whether you talk about federal cases or local cases, these are local people, and they feel like they're being shut out, and they're being told to be quiet, and they're just asking questions a lot of the time. But there are a number of different ways where the alderman can have a campaign site and a public official site. A number of very prominent, famous, world-renowned politicians use this tactic, including Bernie Sanders, the senator from Vermont, who was a city Burlington mayor, and then a congressman, and then a senator, and then in both bids for the presidency of the United States, had a campaign site for the new office he was running for, as well as maintaining his public official site for the office that he had maintained at the time. And on one, he could communicate any number of things and monitor that and dispose of things that were inappropriate. And on the other, as he was running for president but remained a senator, on the senator page, that was a confirmed politician account. And so he had to maintain all decorum and all of the rules according to the First Amendment rights and everything. Mike Gallagher is a local congressman to the United States House of Representatives. He represents the 8th District of Wisconsin, and he has both a campaign site, which is still active and still public on Facebook, as well as his official declared and confirmed congressional Facebook account. So when you're running for office, there are no special rules that give an incumbent less of an advantage, I would argue, over the new incoming challenger. In fact, I would argue the opposite, because the incumbent has two opportunities then. One, in order to dictate whatever communication they would like and to delete and to erase and remove whatever, what have you, on their campaign page, but also to still have their confirmed current office page, which they have to abide by with the First Amendment. But they have two opportunities there. And there are a number of politicians that amalgamate those into one and then just decide to kind of merge those two and the bases of people that follow each page. But people sometimes keep them separately, such as Senator Bernie Sanders and Congressman Mike Gallagher. And there are, hundreds and thousands of people across the globe who take this approach. This isn't some trick. That's not widely known. This is something with anyone who's familiar with social media. You can see what I'm talking about is true, and this is a workaround in a way that the people at the federal level find that this works. So there's not an argument here. I would argue that that would enable someone to remove people's expression when they're asking honest questions about the city, about the county, about their community and their neighborhood. They feel like they're being shut out. Then their participation, input, and opinions are not appreciated. In fact, just the opposite. And there are quite a few combative examples that you can find in the exhibits where they've addressed it in private, not in a public place first, but try to be decent and address it privately with the alderman over private message, and simply was shot back with the "I can delete whatever I'd like to" kind of thing. And that's not the kind of discourse that should be happening here. That's not at all officials should be doing. And I can't stand by that sort of behavior, which is why I decided to take this up on behalf of these people. Furthermore, all of the posts that I've submitted as exhibits that I can provide as proof that these people did in fact post things and comment things that were deleted, although there are dozens that can't be proven because they were just deleted. And so there's no way to be able to prove that those things even existed in the first place. There are still a number of exhibits which I have submitted that prove that things were posted and deleted, because these people started to catch on that their things were being deleted, and so started having to screenshot their conversations with the alderman ahead of time because they weren't sure whether or not it would survive the next day. And that's just ridiculous that someone would have to go to that length in order to communicate with their alderman. But they did that anyway, and none of these exhibits or examples occur within a campaign period. They all occur outside of campaign time, in between the interval of campaign year. So none of these are campaign issues. The account is not campaign related, or if it is, a very minority amount of those posts are. And these are city issues, and they talk about the city, and they talk about local affairs that they have concerns over. And so my next point that I want to bring up here is, if that's not grounds for meeting the social media policy, then I'm not sure I understand the point of the social media policy, because if Alderman Vanderleest is being paid through the city by taxpayer dollars, and whether or not that constitutes being an employee of the city or not, I'm not sure. Honestly, I don't know the logistics of that or the specifics, but city social media has to adhere to federal, state, and local laws. That would mean that it has to adhere to any number of laws where freedom of expression are upheld, and it would include open records requirements. Any content that's maintained in a social media format that is related to city business is supposed to be public record, and that's stated in the social media policy. So if a majority of this page that is city related, that has been dictated by Facebook to be, which is a rigorous standard that they apply for themselves, if this does indeed regard city business, and it's by a confirmed public official who is an employee of the city, or is employed by the city, or employed by the people to the city, or whatever the case is, then I'm not sure why the content wouldn't have to be managed or stored or retrieved with applicable laws, and why it wouldn't have to be maintained. in the same sort of format that other city business, which is posted on the city-run accounts would be. If he's an extension of the government there, then I'm not sure why that wouldn't apply. But that's my argument on that. And I guess I just kind of want to cool it down here and come to a close because I've been talking for a long time. But you know, this is an elected official who I'm sure does good work, and I'm not you know, I'm not doing this for any sort of vendetta or whatever the case is. This is real people in the community who stepped forward when they did not have to, and they should not have had to, because there are many people who are not accounted for in this complaint who did not want to step forward, but still had the same concerns. This is a widespread issue, and it may be in a number of other districts, I'm not sure, but if this is an issue that's being faced, then it needs to be addressed, particularly in this district. There are dozens of people who have faced this issue. They're being silenced. There's no communication occurring, which allows them to connect or correspond in a public way with their alderman, besides going to the meetings. And we all know that's not always an option, especially when they occur in person and people have busy schedules and families and jobs. So how is someone like this held accountable when they're not acting in an ethical way? And I'm not an attorney, and I'm not a law professional, so I don't know all of the specifics that we're going through here today, and I can't argue to all of those bits. But I can say, as a layperson who's attracted to helping people in the community, and that has inspired me to do this. Is this ethical behavior, and is it ethical by the standard of the code of conduct, which is supplied online and is visible to anyone who wants to run for office or is currently in office? This isn't something you have to look for or you have to scavenge for. This isn't hidden anywhere. I'm a member of the public, I'm a private citizen, and I found this very, very easily. And it could probably even be asked for at the mayor's office or anywhere, I'm sure. It may even be provided to city officials when they're sworn in. I'm not really sure because I haven't been sworn in, but you know, I think that this is something that's easy to find. And if you can find this, and if you're going to apply for this job, and if you're going to promise to do this job and swear to do this job in an ethical way, which all of the city council people have, then you should know what you're signing up for. And I think it's not difficult to check your behavior online or in person according to these standards. Are you being ethical? Are you being respectful and appreciative of the public's participation, input, and opinions in a personal public forum, on the internet in a public forum, in any communication with anyone at a professional level, whether it's public or private? And I don't see that happening here. And this is the only thing that I could really do in order to try and remedy some of these symptoms. But this is a larger issue, and you know, so I can only apply it to this one issue with the social media. But I would ask that you take a look at the code of conduct and a number of the arguments that are made here, and try and think as ethically as possible, as I know you will do. And there's a lot of rigmarole and a lot of legal stuff that I'm sure it applies, and but this is my argument, and I hope that you'll consider it, because these people have no other course of action and no other way in order to be heard when they're being silenced like this. So that's my counter, and of course I can answer any questions.
Thank you, Mr. Knight. I've had the privilege, I would say, to serve on this ethics board for more than 20 years. So that kind of dates the board itself. It was, the ethics board was created, to my knowledge, decades ago. And it was originally charged with dealing with the city's code of ethics. And that code of ethics is based on the state statutory code of ethics for local elected officials. About a decade ago, maybe a little less, the city, in its infinite wisdom, city council, decided to create a code of conduct for the elected officials. So with the code of ethics, we have a lot of statutory and attorney general opinions and other guidance to guide us on what we're supposed to do with that. Unfortunately, with the code of conduct, we do not have that advantage. The code of conduct was a pure creature of the city council. They created it, they edited it, they monitored it, and they established it. And unfortunately, it gives us as a board very limited authority, very limited jurisdiction. And so we are limited to essentially what's on the paper that we've all looked at, the code of conduct. And so, Mr. Knight, I'd ask you to address this. As we've noted and as was pulled up by Mr. Kelly, that section 4 is divided into 2 sections: public meetings and non-public meetings. And the section that you quoted accurately is under the heading of public meetings. Now, I understand your analysis and the work you've done was spot on here in terms of what is a public forum when it comes to social media. But I'd like you to address how the definition of a public meeting gets expanded under this code to include a public forum outside of a scheduled, noticed, called public meeting that we are all familiar with: city council meetings, committee meetings, this meeting. They're all published, they're all noticed and scheduled and all those good things, and they're published in the paper. So how does this public forum concept that's under public meetings get expanded outside of the public meeting heading of the code of conduct? That's my question. How does that, how are we, what authority do we have as a board to accept that definition? No question that it says public forum, but the issue is it's under the heading of a public meeting when there's another heading for how officials are supposed to act outside of a public meeting.
Sure.
So if you can address that for us, that might be helpful.
Sure. Well, I would first point out that under Section 4, it doesn't give a definition of what constitutes a public meeting. There's nowhere there that says this is the strict definition of what a public meeting is and what constitutes that. And so I think that maybe it's open to interpretation. I think that a public meeting would, in the most general sense, be a gathering of people or a meeting of constituents in public. And the internet is a public place. It's not private. And there are sections of the internet which are private, but in this case, we're talking about a very public place where people can meet. There are message boards, there are online chats, there are public forum pages such as Facebook. And that's, that is, although, like you've mentioned, that's an internet public meeting, a public forum. I would say that there's no definition here of what exactly the public meeting has to be. And I know that there are public meetings that are called officially by the city, wherein people are, like in this case, they conduct themselves within the manner of Robert's Rules of Order, and everything is very professionally laid out and ahead of time with the schedule. And but in this case, it doesn't address those. It just says in public meetings and conduct towards the public. So I think that this certainly addresses the conduct toward public people in public when people are meeting in public. And I don't know that there is a definition here that says in a material or physical manifestation of a meeting or an internet meeting. So discounting one could be just as easy as discounting the other.
Mr. Knight, I understand that point. If you look at what Mr. Calney has pulled up here, it's section 4, and under the heading of public meetings, the phrase of no sign of partiality, prejudice, or disrespect, it should be evident. That's in the sort of preamble to the public meetings section.
Okay.
But when you get into the subsections A, B, C, and then D, it does seem to talk about a public meeting as would come under the definition of a public meeting that Attorney Miller addressed, that being a statutory meeting that constitutes a public meeting. So it talks about speaking in front of the the council. It talks about the mayor allocating time to people to speak. It talks about a number of other things that appear to suggest that this public meeting component is, in fact, even though it's not defined, as you said, correctly noted, it's not, the public meeting isn't defined. It seems to point us as the board in the direction of what we all know as a classic statutory public meeting. So, you know, again, the phrase public forum, I understand how that applies and how the Supreme or the federal courts of appeals have addressed that in both ways. But again, we're limited, appears on this sheet of paper in front of us, section 4 of the code of conduct. So again, anything you can add, I'd like you, if you could, to address how this whole section, not just the one line pulled out of the preamble, but how this all pulls together from your perspective of how does a public forum on an internet site come up under a public meeting as it appears to be reflected in this document.
Well, I would say that it's not just a line, it's the entire preamble that I'm referencing almost, besides the first sentence, but that's just as applicable. And it doesn't state, like I haven't expressly utilized any of those A, B, C, or D stipulations under the preamble. But if the preamble is there, then that must be able to communicate something of its own importance. And so I think that I'm citing the preamble in a general sense. I understand that I'm not citing any of the specific A through D stipulations under that. And those go on to directly communicate a definition of public meeting as a public hearing which is held, wherein someone would speak in front of the council in a physical sense, or even like this virtually, which occurs, which is certainly utilizes the internet as well, because this is not a physical meeting. So I think that already you have crossover there, and that's probably a good example. And I think that either way, and I know what you're asking me is something very specific from these sections, but there isn't something from these sections that I decided to use, because I don't think that there's anything here that adequately, in A through D, adequately expresses this situation. And I don't think that it negates the seriousness of the situation or that it occurred. I think that it's addressed most easily and in a very broad sense. It's addressed by the preamble, and almost everything in the preamble correlates to this case. And so I think that's the best answer I can give to that. There is a section of this document that appreciates the situation, although it's in a general sense, it's flexible, but it still does that job, and it's in this document. And so I think it should be held with as much seriousness as any of the very specific definitions later on, just because it's not given its own definition in a section E or F under this section 4. I think that it's still a situation that has occurred and can be counted under the definition or the lack of definition in the preamble.
Board members, any of you have any questions for Mr. Knight? I do intend to give Attorney Miller a chance to respond, but before we leave that, do you have any questions for Mr. Knight?
Chair, I actually have a question for anyone who can answer. When was the Code of Conduct drafted? What year? Do we know, roughly?
I would say roughly 5 years ago.
5 years ago, okay.
It was, there were many iterations of this before it got approved. The last draft, the one that we have before us, was prepared by City Attorney Jim Miller. So that might give us a time frame
Okay.
when it was done.
Certainly it was drafted during the time period that Facebook was around, I guess was my question. So social media existed when this was
Yes.
drafted. Okay,
Yes.
thank you.
Yeah, I started ethics when I was elected 5 years ago. And I believe the current copies that we have now were in place before I was elected. So
Right.
definitely at least 5 years.
This is Vanessa Chavez. I just looked it up and it looks like we saved it as approved in September of 2015.
So it's 6 years ago. Okay.
Any further questions from any other board member? All right, Mr. Miller, any response to or rebuttal to?
Yes. First off, I
Knight's
think
argument?
Mr. Knight has very eloquently pointed out a problem. And I think, as I stated in my opening remarks, the problem is not going to be solved by punishing Mr. Vanderleest. The contrary, I think the problem needs to be solved by the by a communication to the city council to clarify this with specificity as to what city council members may or may not do on social media. And this ambiguity, difficulty in understanding what's expected, has exacerbated the problems here because a city alderman know enough, assuming he or she is able to do it, to preserve the exchanges with no expectation that his or her deletions or restrictions are going to be reviewed by the ethics panel, with the heads up or with a forewarning that the ethics panel is going to review your conduct on Facebook. Then we would have a complete record, at least under the for prudent city council members, a complete record of what's going on, as opposed to the recitations of only perhaps half of this or whatever's preserved at this point. So we have a very incomplete record because of the ambiguity and nebulousness of the code of ethics as to whether social media was to be, or what you're supposed to do on social media. And if it's 5 years ago, it seems to me that if the city council wanted to speak clearly and coherently on conduct of social media, it could have done so. And as I said, I think Mr. Knight points out a very substantial problem, and the problem is remedied by the city council revisiting this and putting together very clear guidelines for its members to observe. Now, with regard to public forums and the morphing of the phrase public forum in Section 4, what we have here, well, first of all, this is a hyper-technical area of law, and it befuddled me for quite some time until I read 8 or 10 cases. I am not a First Amendment attorney, and this is a very complex and, as I said, hyper-technical area of law. Now, the term public forum is a term of art in First Amendment law. In fact, I'm quoting from Price versus the City of New York. And there are public forums that are present in First Amendment law. There are limited public forums. So the fact that the First Amendment law terms of art jive with the Section 4 is an absolute chance occurrence. I don't think the City Council is choosing to use the term of arts of First Amendment law in its basically plain vanilla recitation of what's happening in a public meeting. But this is extremely complex, and it took me a lot of cases, reading a lot of cases to figure out what's going on, and to expect that a 72-year-old semi-retired electrician is going to read the same cases as I did, understand it, is just unbelievable. This is a very difficult area of law, and I don't think you can keep up with it because it's constantly changing. And unless you're really an expert in the area and pay attention to it all the time. What it underlines here is the need for the professional staff to summarize what should be the applicable public policy, and for the city council to basically promulgate clear guidelines for its members to observe, excuse me. With regard to some of the niceties of Facebook, it would have been really helpful if Mr. Knight had put those in written arguments. Frankly, I am not a user of Facebook in any meaningful sense. To address the distinction between politician and somebody who's running for office, I can just recount the history of the website as I understood it. I can also recite that for many aldermen and city and county board members, they are constantly running for re-election. I know that Mr. Vanderleest's brother, who was a city council member for 20 years, used to constantly run for office by distributing a newsletter. So it is a constant campaign for many of the members of these bodies, and that has to be understood. I don't know that one can make a clear distinction between the transmission of information by a public official for just communication and the transmission of public information for the purposes of being re-election. The two are intermixed and probably can't be separated. A public official is always trying to curry the favor of the public for his next or her next election. So I don't see the distinction between campaign posts and the transmission of public information as being significant. With regard to whether they can communicate with their alderman or county board member, well, you know, it seems to me that the ultimate accountability is to run against the individual, to utilize other avenues, be it other Facebook sites, be it writing letters to the editor, ultimately just running against the person until he or she is defeated. I would note here that I believe Mr. Vanderleest won by a large margin, something like 60%. So apparently the bulk of the populace is satisfied with his representation. That being said, it is indeed regrettable that that everyone is not permitted to communicate with their aldermen, but as I said, or other public officials, but as I said, it's clear First Amendment law that the public does not have an absolute right to communicate with a public official. Thus, my letters to a U.S. senator might not be read. They might not take my phone call. They might not talk to me if I see them at Lambeau Field. This is entirely the same as we see in the ordinary course of business. So I think on balance, I only differ with Mr. Knight as to how this problem should be solved. I don't see that punishing a 71-year-old semi-retired electrician for his lack of knowledge of First Amendment law is going to be really productive of a solution to this problem. Rather, the ethics board should communicate with the city council, or the city council members that are present here tonight should take it upon themselves to resolve this problem once and for all, to put forward a very clear-cut set of guidelines that the city council can observe at their peril. So for all those reasons, I think this should be dismissed and it should be placed in the lap of the city council to resolve it once and for all. Thank you.
Any board members have it for for Attorney Miller? All right. Anybody have any further questions for Mr. Knight on this motion to dismiss issue? All right. I will assume that we are closed with this issue. The last motion that looks like we need to address is another motion to suppress filed by Mr. Knight. That one appears to be dated October 2, 2020. Mr. Kelly has pulled that up. And so, Mr. Knight, I'll give you an opportunity to address that motion.
Thanks. This was a simple motion that I filed, just arguing that I didn't think any of the points which were just brought up in the last argument, which is in response to the document and motion that was filed and brought up by Attorney Miller. I didn't think that any of those applied to the language of the, basically of the preamble of Section 4 of the Code of Conduct. I still think that that those are all applicable, and I still feel very strongly about that. And so I wasn't sure about the relevance of any of those issues because, as you just saw, anything that was argued one way could just be refuted again in response. So that's what this motion is. It's a simple motion saying I didn't think that it was relevant, and I would still ask that that everyone take a look at the exhibits, because a number of things that have been brought up in this last motion are refutable by exhibits that have been submitted, and maybe there'll come a time for that conversation. But I still feel very strongly that there's grounds for this complaint to be made, and I think it happened over a number of years. This is not an isolated incident. This is repeatable, and so I don't think that that I understood any of the argument and how it applied to everything that I know about this. That's all.
Mr. Miller, any response?
Well, I think obviously my brief was relevant to all the subjects raised in this proceeding, but I guess I would emphasize that there's really nothing particularly novel about this controversy. Representatives have been ignoring or have alleged to have ignored constituents' wishes since there have been representatives. What we have here is a variation in the form of not listening to people, or not reading their letters, or not taking their phone calls. Somehow we feel that everything has changed or it's been transmuted because these actions are taking place on the internet as opposed to via United States mail or a phone call, or before that a telegraph. These are common concerns with regard to every type of representative. There's nothing particularly novel here. If in fact the city council is concerned about this, then they should have a specific social media policy for its members. If it was produced in 2015, certainly the Facebook and Twitter and the like were present, omnipresent perhaps in everybody's lives, and the city council could have spoke to this in specificity. At this point, I've made my argument several times. I think it needs to be resolved by the legislative body, not by the Board of Ethics rewriting ordinances. In fact, I think it would be very problematic for the Ethics Board to rewrite ordinances in this circumstance. Under those circumstances, I think the matter should be dismissed, and I would join with Mr. Knight in trying to have the City Council solve this problem once and for all. Thank you.
Mr. Knight, go ahead.
I want to make it clear that this is not, as it has been stated in the formal complaint and in our deliberation here, this is not simply people being ignored. This is people over a number of years having not only been ignored and or not given access to communicate, but denied it sort of ad infinitum. They're not able to communicate because they've been blocked. This is not someone who can't get a hold of. This is intentional blocking of communication. This isn't just ignored. They are being deleted. their letters are not only not being read on the internet, they're being removed. And when there is the opportunity given for communication and they communicate in a public setting, they're being deleted and removed entirely. They're disappearing, and there goes their opinion, which they were asked for. So I think it's almost malicious. I think it's being too innocently as these people are being ignored. They do not feel that way, and the evidence does not point to that. They're not just being ignored. This is a 4-year or a 5-year habitual behavior where these people over and over are being deleted and removed. And then when they communicate privately about it, and as you'll see in the exhibits, it's almost gloated about that they were deleted. It's almost bragged about back at them that they have the right to do so, and they are happy to do so, and they do not want to free expression as long as it's not in line with the form of thinking of the alderman. I think it's not innocent, and I think it shouldn't be explained away so easily. This is a serious matter, and I think that these constituents and these taxpayers, quite a few of them, feel very strongly about it. So I verify that this isn't just being ignored, as it's being stated here. This is malicious behavior, and if it's not Alderman Vanderleest, then it's someone else running his page. But no matter who it is, someone is responsible, and Alderman Vanderleest is responsible for allowing that to continue. And he's known about this page and that these things have been going on, or should have known, since he's been in office for 4 years. So I think that I wanted to clarify that I think it's more serious than that.
Any board members have any questions for either Attorney Miller or Mr. Knight?
No.
No. All right, then I believe we're ready to move into deliberations. Mr. Knight, Attorney Miller, thank you for your efforts to enlighten our board here on these issues. We are going to go into closed session now and to deliberate on this. Before doing that, Attorney Calney, anything you want to add before we close this open session?
Well, there's two things I want to observe. First of all, there's been a lot of argument raised, and the ethics board, with its duty to interpret the code, I think has a lot to consider. And we've been at it for over 2 hours already. So it's already been a lot for the board to take in. I think it makes some sense for the board to deliberate tonight, obviously, and at least start deliberations. I think it may be necessary for the board to meet again to deliberate after tonight. We'll see. I could be wrong in that. I also note that we continue to have problems with the transmission and reception. Frankly, I think that doing a hearing and having testimony taken, if we go in that direction, I know there's a motion to dismiss pending, would be kind of troublesome and might not afford due process. Mr. Miller has previously stated that he doesn't like the idea of having to go to a hearing in this type of form. And tonight kind of emphasized that again. People were getting knocked off, not being able to hear everything. So I have two comments in that regard. Number one, we have another meeting scheduled for 2 weeks from tonight. We have a lot to deliberate about. And I'm anticipating the board's going to want some feedback before they make their final decision on this from me. So I just want to suggest that it is possible, and we may want to consider not having the hearing in 2 weeks, but instead deliberating and giving our opinion within that period of time. I just want to put that out there as a possibility, so that the parties aren't surprised if that winds up happening. I think that's a realistic concern. Certainly, if they have comments regarding that, I think we should invite them to make those comments at this point.
Attorney Miller, Mr. Knight, go ahead.
I'm perfectly pleased with any amount of deliberation. I don't think that there's a timeline that I want to see occur. I do want for people to have the opportunity in order to speak to this, because I think that the people in the community want some closure on it, and I think they want to be able to speak to the things that that have occurred here. And obviously, there's a motion to dismiss, but I would still like for the opportunity for those people to be able to come forward and speak, or for a number of them who feel intimidated or feel threatened to do so, I would like to still subpoena them so they still have the opportunity to do that, because they have in the past voiced that they want to. And I hope that you deliberate as much as you need to about it. I think it's a very serious matter, and I appreciate you guys putting thought into it in order to rectify it. Thank you.
Mr. Knight, question. Attorney Miller has brought up the concern about doing this by video and rather would prefer to do it in person. What's your position on that?
It's not a very large group of people if it's all done at once. I think that in person it can be, whether it's now or later, can be done in a safe way, as long as other meetings are occurring that way. But I think that no one that I've asked, or I'm sorry, have presented in the complaint or the list of potential witnesses to be subpoenaed, none of them have transportation issues and so can make it in person. But I think all of them as well would be fine appearing like this. I certainly don't have any issue appearing virtually like this over Zoom if it works for everyone. Whatever would work. I'm just trying to give these people the opportunity to get some closure on this. Whatever works, you know.
Very good, thank you. Attorney Miller, any comments on your side?
I'm not clear what Mr. Conley wanted me to address some question.
No, basically what I was saying is, I think it's possible that we're going to be amending our scheduling order as a result after we deliberate, as a part of our deliberation, and that we might not be having the hearing in 2 weeks.
Oh yeah, that's fine. And quite honestly, when I made my statement about the in-person hearing, I had no conception that we'd have such a increase in cases, and I guess I'm not much of an epidemiologist, but you know, I'm not trying to endanger anybody's health over a blind insistence on in-person hearing. I mean, we're going to have to figure out how it can be safely done. So I'm fine. You know, I recognize these are very difficult issues. It took me a long time to attempt to get a handle on these, and I expect it's going to take some time for the ethics board to discuss this.
Very good. Well, again, non-board members, thank you for your time and efforts tonight. We will now be going into closed session. So next on our agenda is deliberation and possible action on motions filed in the matter of the ethics complaint against Alder John Vanderleest, filed by Mr. Carl Knight under the City of Green Bay Code of Conduct for Elected Officials. And so it reads, the board may convene in closed session pursuant to sections 19.85 sub 1 sub a of the Wisconsin statutes for the purposes of deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. The board will thereafter reconvene in open session pursuant to section 19.85 sub 2 of the Wisconsin statutes to take action on items discussed in closed session if appropriate, and to consider the remainder of the agenda. So is there a motion to adjourn to closed session?
I'll make that motion.
And I will second it. Lindsay, you want to do a roll call here for the vote?
Sorry, just bear with me 1 second. I'm having some technical difficulties.
Certainly.
You can go ahead and do the vote. I don't know if you can do it on the board. Otherwise, if you want to just do a voice vote.
Yeah, can we do a roll call vote? So call the roll and each one will vote as you call their name.
Alder Galvin,
Aye.
Attorney Vandecastle? Did you say yes? I can't hear anything all of a sudden.
I can hear you, Lindsay.
Bill, can you hear?
I can hear, yeah.
All right.
Okay,
Or
I
Pat
can
Bill.
hear. I can hear Bill now. I apologize. I just couldn't hear you for a little bit.
All right, yes, I vote yes.
Thank you. Cheryl,
Aye.
Aaron,
Aye.
All right. Any
that passes 4-0.
That's all of us, so there's no opposition. So we are adjourned into closed session, and we'll proceed accordingly. So I think we've got a couple of people that still appear on my screen that probably shouldn't be in the session.
For some reason, I'm not able to create a breakout room like I had intended to do, so I'm going to have to put people in the waiting room.
Okay.
Unfortunately, as the host, I won't be able to put myself in the waiting room. Jim, if I make you a co-host, are you able to put the City of Green Bay in a waiting room?
I really don't know that.
Okay, that's fine. Let me just take care of this.
Lindsay, your concern is that you would move out of the closed session?
No, that I would actually be in the closed session, and I shouldn't be since we're conflicted out.
Oh, okay. Okay, so I'm seeing Alder Vanderleest is none.
Okay, so it's just me.
Can we just trust that Lindsay leaves the room for now, or is there something we could do? Cross your fingers.
Does the recording have to session?
I can turn my video on, and you. Oh, I do have to stop recording. I'm gonna resume.
I've run into this in other municipalities, and we weren't able to get the host out.
Okay.
So.
Yeah, and we still
Attorney Mathis?
we still
Yes.
host around it so that when we're
What we're going to do
back to
is
open
setting
session.
that we are not able to correct at this time. So instead, I'm going to give you to log in and send you a Zoom meeting for from the law department's account, so that you can put them into that meeting separately, and we'll keep this one open. And then when they're ready to come back, they'll just need to come back to this meeting. That's the only solution I can come up with right now.
Thank you, Attorney Chavez. Does that make sense to everybody?
So when we're done, we're going to close out of this Zoom when we're done with deliberations and sign back into the Zoom.
So she's going to send you an invite for a separate Zoom meeting, and you'll do your closed session in there. And then when you're done with closed session, come back to this meeting.
Okay.
So we're going to leave this one on. This one will keep going.
You're anticipating a lot of technical part here.
So
Well,
all we need to do is log into the new Zoom. You're going to send us an email right now, right?
Attorney Chavez is yes.
And we just need to log into that email Zoom.
When we're done with this, or right now?
Shortly. So I will tell you when to log into that meeting.
Okay,
like I said, we will
let's.
keep this meeting open, so you'll come back to this one once you guys are done with your closed session. And so that will be a completely separate meeting for you to have your closed session.
All right, before you do that, let me just interject and ask a question. Again, we've been at this for coming up on well beyond 2 hours. Do we want to delay the deliberation tonight and just wait till 2 weeks from now and do our deliberation then after we've had a chance to think about this a little bit? And then
I'm so sorry. Before you guys talk about that, Attorney Chavez, I put people in the waiting room, but this is still recording. I don't know if they're technically in a closed session right now, so should I stop the recording?
I
Or
would
let
just bring
people
everyone
back
back
in?
so they're aware of what's happening.
Okay,
Because I don't feel that any of this is privileged.
okay.
We're not
I'm so
deliberating, we're just talking about
Yeah,
schedule.
So sorry, everyone.
So, again, from the board's perspective, do we want to go forward with deliberations tonight, or do we want to adjourn the deliberations for 2 weeks? I mean, that would be.
I'd vote to adjourn and deliberate. This is a lot. This is a lot of information.
It's a long sit, I think. And then,
Yes.
you know, to duke it out, I wouldn't mind waiting a couple of
We'll go
weeks.
back at this in 2 weeks.
All right,
All right,
I would concur. So,
Do you want to reconsider the vote to go into closed session, maybe?
nope, we've
Or
gone
just-
into closed session. All we're doing in closed session is agreeing to adjourn the closed session for 2 weeks. So I think we can go back out of closed session and report that to the other parties and go forward. Adjourn.
Technically, this has all been not closed session.
Right, but we did vote to go into closed session, so I think we got to put it out.
Motion to move into open session.
Second.
We have a motion and a second. Again, roll call if we need it.
Yeah, you do.
All right.
Lindsay, call it off.
I'm getting there. I'm sorry. Alder Galvin.
aye.
Bill?
Aye.
Cheryl?
Aye.
Aaron?
Aye.
That is unanimous.
All right. So we are back in open session. So the results of our very short closed session were that we agreed to adjourn deliberations until October.
Let me look.
I think it was the 19th.
I believe.
The scheduling order here.
Oh.
Just a second, it's coming up any minute now.
October 28th.
I think you're right, Bill.
28th?
Oh, great. I already had the file open. I didn't know it. Okay. Yep, October 28th at 5 o'clock. So I take it we're gonna use
That was the action taken in closed session to the extent that there was a closed session. And so notice will go out to the parties that we will be having a closed session on that date, beginning at 5 p.m. to begin our deliberations. And that parties will be notified accordingly. I don't know if there's anything else on the agenda. Anybody have any further comments before we move for adjournment? No. Is there a motion to adjourn?
Motion.
We have a motion.
Second.
We have a second.
Second.
All in favor of adjournment, signify by saying aye.
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 Aye. Any opposed? Hearing none, we are adjourned. Thank you all for your time and effort tonight. Again, some thorny issues here to think about, but I think this is a good step here, giving us a chance to think about some of the things we heard tonight and review our notes, and then we'll come back prepared to deliberate on this in 2 weeks. Very good. Thank you all.
All right.
Thank you.
Hi, everybody.
Good night.